Hello everyone, welcome back. So, is it clear? Good. Somebody was just asking me about the wage levels. How do we decide the wage levels for a position? Right? Let me go through that before we go to the next topic on the payrolls and everything. Okay? So, rule of thumb, right? Whenever a position requires just a bachelor's degree, minimum, right? It's level 1 position. Okay? Whenever a position requires a master's degree, it's level 2. Whenever a position requires bachelor's plus 5 years of experience, it's level 3, right? When you're processing GC applications, you mention about the travel requirement. So whenever there's a travel requirement for a position, everything jumps by one level. So if a position requires master's degree plus has a travel requirement, then it will be classified as level. Anybody wants to say? Which level will it be? Level 3, because level 2 plus 1, right? This is for the GC applications. Okay, so a lot of people have been asking us, hey, why do we get higher wage for when you're doing GC applications when compared to H1B wages, right? So when you're doing filing H1Bs, you're looking at the work location for the beneficiary, so which could be anywhere, right? Whereas when you're doing GC applications, you're running you'll be doing the wages from your principal place of business, because you're stating that the position requires travel or relocation to various places throughout the country, right? So for example, if your company is based out of California and you have an employee working from NC, North Carolina, right? So when you're filing the H1B, the wage will depend upon the NC location. Whereas when you're filing the person's green card, right, now you're looking at the company headquarters, which is in California. As I mentioned, for example, if you the wage depends upon the job location, right? The SOC code. SOC code means like the job duties, right? The job duties is decide which SOC code to be used, and the position requirements, right? If the position requirements is high, then it will be higher wage level, right? If the position requirement is just bachelor's plus 2 years of experience, then it will probably be like maybe level 2, and if there's a travel, then it jumps by one level. Now, a lot of people have been asking us regarding the wage levels for H1Bs. Whatever I just mentioned right until now is for the GC cases, right? So now regarding H1Bs, usually whenever you whenever you want to file a case, right? Then you send us the job duties, and we send you the, hey, this is the level 1 wage, level 2 wage, level 3 wage, level 4 wage, right? So typically what happens is, the reason why we do not recommend level 1 wage, right, is because there it states that the position minimum requirement is bachelor's. Of course, it should pass the mustard, but most of the times, depending on the SOC code, it says that 95% of the positions require a bachelor's degree. Some do not, right? Especially if it's for a systems analyst position or computer programmer, they will have a lower percentage of positions that require a bachelor's degree if you're going with level 1, right? That's a reason. To play safe, we ask for level 2, but we have filed many cases under level 1 without any issues, right? All you got to prove is that this position is not complex enough that it would fall under level 2, right? But at the same time, it's complex enough so that the position requires a minimum of a bachelor's degree in a particular field of study, right? If you want to play safe, go with level 2. But it's not always possible for you to pay level 2 wage, right? So when situation arises in those cases, we have to be very careful with the drafting the job duties and also stating the position requirements. Does anyone have questions regarding this? Okay, so sometimes you may be receiving high wage levels if you go with the FLC data center website, right? So in those cases, we could also request for alternative wage survey. I'll give a small example. if you're filing a software developer position in SFO, right? The typical wage would come around like 160K or 170K, right? But if you do a alternative wage survey, especially if the person isn't like software developer and testing, QA automation engineer, right? So the actual wages would be much lower than that. If you do an alternative survey, we can use that one. But the problem with using alternative survey is that you have to request it for every position, because now the position change, the wage changes based on the position as well as the work location, right? So unless you have a bunch of people working from one location, we usually do not request for alternative wage service. Okay. Also, there is a risk involved here, because there are a lot of alternative wage servers that are not being accepted by USCIS, right? So typically, in order to avoid all these situations, we just go with whatever is in the FLC data center and also go with level 2 because it's safer. Okay, but that does not necessarily mean that you have to change your business strategy, right? So if you have a situation wherein you are not able to pay wage 2 level, then you have to bring it to our attention, and then we can help you with redrafting the job duties or like maybe working around the situation. Does that answer your question, Pradeep? That's a good question. So all it depends upon is the SOC code that you choose. Okay. The good thing about any IT position, right? If you give me any IT position, I can redraft it in such a way that I can make it fall into any SOC code that you ask me to. Because typically any IT position involves design, develop, test code, gather requirements. These are the only 4 words, right? Design, develop, test code, and then gather requirements. With these 4 words, I can rephrase the whole job duties. Okay, I can make it fall into a software developer, or if you want me to even make it a database administrator also, we can do that. Okay, as because I know a lot of SOC codes don't even make sense, right? And these USCIS officers, most of them are Department of Labor officers also, they don't know or they don't have much knowledge about the skill sets. For example, if you have a software developer position and one requiring maybe one requires, like maybe it's a big data developer, right? And then there's another one which is a testing position. They think both of them are the same. If it's an automation engineer position which requires Selenium, right? So you cannot expect a person to get paid the same wage if the person is working on Selenium versus a big data, right? But as per Department of Labor, they think it is the same thing. So the burden of proof is on you to articulate your job duties in such a way that you can satisfy their requirements. Same thing for GC also. It's easy to redraft the job duties in such a way that we can make sure that the SOC code, like if you see that, hey, the salary for this SOC code is so high, you can always redraft it. This like especially for clients who are in California, you got to be very careful because the wages are so high. California, New York, of course other places also, depending on where you're based out of. Does anyone have questions regarding the wage levels? Because I know we have only a little bit time, so I want to go to the next topics. Anyone has questions regarding wage levels? Okay, let's go to the next one. Okay, payroll. This is a very important topic. How many of you hire OPTs? Good. How many of you issue offer letters to these OPTs? Good. How many of you really run their payroll? Okay. Okay. So whenever you hire a candidate, right? Okay, you have to look at 2 things. One is their immigration. The other one is Department of Labor requirements, right? Based on the immigration requirements, a person can be on unpaid internship while on their OPT, right? But what dictates whether a position qualifies for unpaid internships is dictated in the fact sheet 70, sorry, 6, which one, 71? 62. Okay. If you look at fact sheet 62, it explains how and when you can classify a position as unpaid internship. Okay. So if the primary beneficiary of that internship is the employer, then the employer cannot classify it as an unpaid internship. So whether you have candidates working, like for example, on H4EAD or GC, citizen, or even OPTs, right? If if they are going through the recruitment process with you, and if you're having them attend visa interviews and all, you have to compensate them. You cannot classify it as unpaid internship. Okay. And the worst thing about this is, if a person has a claim for under unpaid internship, right, it will be classified under the Fair Labor Standards Act, which is a federal law. They can actually file a case in the federal court and make it into a class action, stating that, Your Honor, not only me, there are other candidates also in this company who went through the similar training program, right, and make it into a class action. How many of you are familiar with class action? Yeah. So once the judge certifies it as a class action for the class, then you pretty much lost the case. So you got to be very careful when you are issuing offer letters for unpaid internships. Make sure it meets the guidelines as specified in the Fair Labor Standards Act, fact sheet 62. 71, okay, sorry, 71. Make a note of that this week, because that's very important. There's a primary beneficiary test. You have to make sure that your job duties fall within that category. Okay. Also, the amount of wage that you have to pay for these interns, right? It should be similar to the wages that you pay for a typical intern. As long as it is more than the state minimum wage, you should be fine. Right? Also, you can classify the interns into different levels. You can classify them as intern 1, intern 2, intern 3, wherein intern 1 is maybe somebody who is an unpaid internship. But these unpaid internships can be only for a short duration of time. And during this time, they should be receiving training that is typically offered in a classroom setting. So you cannot say that a person is working as unpaid internship for 6 months. Does it make sense? A lot of times what happens is employers issue offer letters during to these employees. They don't pay them, and the employee can always file a claim against the employer. Okay, so as long as you're paying them at least the state minimum wage, you should be fine. So if they get a project, then you can pay them intern. You can promote them to intern 2 position. It could be a different scale. Does it make sense? Okay, and then I think I also touched upon the exempt position, right? So if an employee, unless employee is exempt, you have to pay them overtime when they work more than 40 hours. Right? That we're clear on that one. Okay, next. Okay, so the other thing, whenever you are filing any H1B petition, right, requesting for a change of status, or sorry, extension of status, I highly recommend that you go back and look at the previous petition. So for example, if it's a transfer, right, and you receive the pay stubs from the employee, ask them to provide a copy of their last LCA to verify that the work location that's mentioned in the pay stubs matches with the work location that was previously mentioned in the LCA. Right? Because if this previous petition was filed for a work location in California and the pay stubs were run in New York, then you will receive an RFE for that. Same thing applies if you're filing for an extension or amendment. Okay, it's very important that you cross-verify the address that is stated in the pay stubs versus the address that was stated in his last LCA or H1B petition. Okay, when you're verifying this, verify the salary also. The other thing, a lot of times what happens is, assume that a person has been, like, he's on bench for 6 months, right? Then somehow the employers, they try to run the pay stub for like July, August, September. And then they try to use it to file for an extension amendment. That's a big red flag, okay? Because even though you did run the payroll for just July, August, September, right, it will have a cumulative number also. the USCS officer is going to look at that number. And they will realize that you have not been running the payroll for the past 6 months, and then they'll issue an RFE on that. Okay, so you have to be very cautious before submitting payroll documents to USCIS. If you have a situation like this, then better to request for console notification so the person can go for stamping. Does anyone have questions regarding this? Okay, so number one, make sure to cross-verify the wages with the pay stub that the employee is providing. Make sure to cross-verify the work location. Okay. Next thing, assume that you filed somebody's H1B for 120K, right? And the person is working overtime, right? When you say 120K, it's $60 per hour, right? If the person has worked maybe 60 hours, right? So now the wage is 110. Okay, let me just maybe just go through that one. I'll go through this. Okay, sorry. So assume that the LCA wage for a position is 120K, okay, which equals 10K per month or $60 per hour, right? If you want to pay the beneficiary 16K, what do you do? Huh? I'm sorry.
The leftover can be given as in bonus amount? Or
Good
type of
question.
incentives?
Good answer, but like you'll have to pay more taxes, right? And beneficiary would not want to do that. Huh? No. No. How long can you carry it? Okay. Lot of employers, what they do is they just put the flat number as 15. Okay. If you put that as 15, it's a red flag, because the USCIS officer is going to question why you're paying them much higher wage than what is mentioned in the LCA. Okay. Instead, what you could do is you could use the same $60 per hour, which is a regular wage, right? You can mention that one. He's getting $60 per hour, 12,000. Then you can have an additional line item for that extra. You can mention it as overtime and then provide that amount. That is acceptable. It doesn't matter. So you see, LCA exemption is for different thing, as I mentioned, right? That is for the displacement of workers and all that stuff, right? So if the position is exempt from the Fair Labor Standards Act, like regarding the wage payment, then the employer has the discretionary power to either pay them overtime or not. Even if they pay overtime, they can choose whether to pay the flat amount or higher amount too. So you should always separate that line item. Okay, so by separating the line item, you're not violating the LCA regulations. You're paying them as per the LCA, plus you're paying them extra, which is allowed. Does that make sense? Okay, go to the next slide. Yeah. So here you're paying overtime or bonus, because a lot of employees don't want you to pay it as bonus because they'll have to pay more taxes. So you can do it as an overtime also. Does it make sense? Any questions on this one? Well, overtime it will be based on the regular this thing, right?
Sir, I have part-time H1B. Okay, can I run regular pay, or I mentioned in LCA it's going to be for 20 hours per week. But
If
we
you
have so much
mention,
amount.
okay, that's a good question. Okay, H1B can be filed for a part-time position, a full-time position, or for a range of hours. We clear on that one, right? So you can file H1B for 20 hours per week, or a full-time position, or by specifying the number of hours, 20 to 35. Okay. If you file the H1B for 20 hours per week, you have to pay them for 20 hours. You cannot be paying more than that, because that's like working without authorization. If you mention 20 to 35 hours, the person has to work anywhere between 20 to 35 hours and you have to pay them accordingly. But when you specify full time, right? The person can work for n number of hours, which is about 30 for 32. So if it's a full-time position, he can work for 60, 70, 80 hours also. And lot of times, this is another issue that I see. Lot of times, if a beneficiary is if an employee is working on multiple projects, during site visits, the employee can clearly say that, hey, I'm working on multiple projects. That's perfectly fine. It's not a violation. It is not a violation to work for more than 40 hours. It's okay to work for 80 hours also, as long as it's a full-time position. Okay? And a lot of times what ends up happening is the employee is going to say something and the employee is going to say something. Now you're charged with perjury. Right? Don't do that mistake. You're perfectly fine to work more than 40 hours. Okay? Also, it's not mandatory that the employer has to pay overtime unless it's specified in the offer letter or employment agreement. Is that clear?
Do we have a limit for overtime?
No, it should be practical. Whatever you are saying as overtime, it should be practical. So you cannot say that the person is working 160 hours per week.
So in this case, like no need of concurrent H1?
Well, you need concurrent H1B if the person is working for another employer.
Multiple. Okay.
Right? So concurrent H1B is needed if a person is working at two locations. Right? So if a person wants to hold two H1Bs, then one will be the primary one, the other one will be a concurrent one.
Okay. So in this case, like if the person is working with multiple projects, so
is it through same employer or different employers?
same employer?
If it's through same employer, no need to file concurrent H1B.
Okay. And
If it's through different employers, then only you file concurrent H1B.
rest of the hours we can keep as overtime.
Yeah.
Okay. Thank you.
And for that overtime, should we justify like by submitting, if they ask for any timesheets or anything, will they
No.
ask for it?
No, it's the employer. The employer has the liberty to choose whatever. Like if,
No,
for example, assume that you're billing 40 hours to the client, right? But maybe he is doing some admin work also wherein you have to pay him for 10 hours extra. That's perfectly fine.
And if the person is on full time, can he work with a different employer? I mean, apart
Yeah.
from concurrent.
Yeah. So, for example, if a person is working part-time or full-time for one employer, right? He can always work for another employer using concurrent H1B, right? And that concurrent H1B could be for a part-time position or a full-time position.
Okay, but we need to have concurrent for sure.
Yeah. So if you have, see, at a time, you can only hold one status, okay, on only one primary H1B. If you want to do the other one, then it has to be concurrent H1B.
Okay.
Does that make sense?
Sure. And that concurrent can be no need of part time, right? It can be 40 hours as
Full-time
well.
also, yeah. We file concurrent H1Bs for part-time positions, full-time positions, and range of hours, all three.
Okay, sure. Thank you.
You can even file cap H1Bs for part-time positions. I know a lot of people don't do that one, right? But you could actually file cap petitions for part-time positions and also for a shorter duration. So for example, if you have an internal project, right? Instead of stating that you have 40 like work available for 40 hours and that too for 3 years of duration, if you have work available, like if you have enough work for only 20 hours, then you can mention that the beneficiary will be working for 20 hours per week and for maybe 1 year or even 6 months.
Sir,
Right? This is especially true if you want, like for example, if you have a short-term project wherein you hire a candidate to work on your internal project for maybe 6 months and later on you want to move them to a different client or whatever, right? In those cases, it is better for you to provide correct information stating that the beneficiary will be working only part-time or full-time for only 6 months, right? That way you get the H1B and later on, once you find, if you want to move them to a different client project, you can file an amendment. That way, you're not providing falsified information to your CIS. Okay, but a lot of employees, what they do is they just file H1B using in-house project for 40 hours, and then they'll say that the project is for 3 years, right? And then they place them at a client project. That is illegal. That means you are providing fraudulent information to your CIS, or you're misrepresenting yourself. Is that clear?
Sir,
sir,
Yeah.
in Corona time and now also one of the consultants working on 2 projects, and salary is more than 200K. Is it going to be red flag or?
No, no. So what you do is you pay them as I mentioned, right? It's perfectly fine for them to work on multiple projects. You pay them the regular wage as per the LCA, then have a next line item that pays them for the overtime pay. Yeah. Not necessarily, but when you're filing for H1B extension, right, through the primary employer, at that time there will be a question asking for provide the most recent H1B petition receipt notice number, right? Yeah. Again, here we have to look at the employment agreement also, because most of the employers, they have a moonlighting clause in their employment agreement. So if an employee is actually working using, even if they're working using concurrent H1B, and if they're violating that employment agreement, they could be sued for that. Any, I'm sorry.
In terms of employee perspective,
Mhm.
is there any risk if
No.
we go for concurrent H1 when filing for green card?
No, no.
Okay, good.
That's perfectly legal and it's allowed by law. So yeah, there's nothing to be worried about.
Sir,
Well, as long as it's not a violation of his employment agreement, he is fine,
So,
right? That has nothing to do with his immigration thing. It has to do with more of contractual thing.
so while going for concurrent H1, do we need to maintain the wage levels?
Of course,
Yeah.
it's the same thing as filing a fresh normal H1B.
Okay, thank you.
Sir,
Yeah.
so while we are paying the additional wages as overtime, so what if the times are not matching to the actual hours? So they'll be working as per the actual hours, but we are paying as overtime. So, but for that overtime, will not have the time sheets, right? The hours will not matching, right?
That's what I mentioned, right? So the hours need not match, because the hours that you submit to the clients are to the client is different from the hours that you actually receive.
Okay.
I'll give a small example, right? So assume that I have placed one of my employees to work for Apple, right? He's working on the project. While working on the project, he has to attend client meetings with me also, right? Our internal discussions, everything. So maybe he's submitting 40 hours timesheet to the client, but when he's submitting timesheets to me, he may be submitting 50 hours because he's working on other things for me.
Okay.
Similarly, maybe he is working on that for the client on the client project. He's working for 30 hours, but I am also putting in some of my time, so I could be billing the client for 40 hours.
Got it.
Right.
And regarding concurrent H1, I have one more question.
Yeah.
So, we have an employee like who's requesting for the concurrent H1. So when we file the concurrent H1, so once the petition is approved, we'll be the second employer, right? So the concurrent employer.
Need not be approved once you file it.
Okay. And what if the actual H1, the primary H1, that employer, what if he revokes his H1?
Then you have to amend your H1B.
So we need to amend it.
Yes.
Okay.
So I'm gonna, like, since we are on the concurrent H1B, I'm gonna give you another thing, tell you another thing. So you know that there are a lot of cap exempt employers, right? Okay. So typically, if a person's H1B doesn't get picked up in lottery, right? So they can work for cap exempt employers. So cap exempt employers are the employers who can sponsor H1B without having to go through the lottery process, right? So most of these are like non-profit organizations or research organizations. So good thing is, if a person is working for these non-profit organizations without having to go through the lottery process, at the same time, they can file a concurrent H1B through an IT consulting firm also. Does that make sense? So assume that like my H1B petition did not get settled in lottery, right? Then I choose a cap exempt employer, and they may be paying me very less amount of salary, but they'll be able to sponsor my H1B, right? Without having to go through the cap. With that H1B, I can work for another regular IT consulting firm using concurrent H1B.
LCA is a mandate for it?
Huh?
For a concurrent visa, we need to file a LCA as well?
Yeah, same thing as a regular H1B. There's no difference. Okay, but you could be using the concurrent H1B as long as the initial, like actual H1B is valid. That's all.
Got it.
So in this case, as long as I'm working for that non-profit organization, I can continue working for this IT consulting firm using a concurrent H1B. Is that clear?
Yeah.
Good, let's go to the next
So
one.
one
Sir.
more-
Yeah.
Been waiting for a while. Yeah. One particular location, second level wage is 120K, and if my location changes to California and my wage is 140, how do employer manage it if he cannot pay that salary? Can we decrease the pay?
You can decrease the pay, but you need to change the job duties too.
Okay.
And you can play with the job duties, right?
We can change the wage level from like 3 to 2.
Oh, of course. We actually received a RFE, like we got it up. Like, so the employer, this exact same scenario. So the employee actually moved to California, right? Yeah. So he moved from somewhere to California. So, and then they were about to file an extension, amendment plus extension. So we had to change it from, I think, level 3 to level 1 or something like that, and got approved. There was an RFE, but we had to justify it. So it is not about what the beneficiary's qualifications are, it's about the position requirements.
So, one more.
Yeah.
So for part-time cap, if you file a part-time cap H1, so what would be the wage level? It would be 50% of the original LCA, or
No, so what you would do is you will mention the hourly wage,
okay?
like whenever you have the prevailing wage, right? There's an hourly wage also. You'll mention the hourly wage at the time of filing the LCA as
Into
well as the H1B petition. But make sure your employee is not H1B dependent or a willful violator. If they are, then make sure you're using it for an exempt position wherein the beneficiary has a master's. If you have none of these, then make sure that your wage crosses that 60,000 mark.
Okay. So
Because if you
is
don't do that
mandate.
one, then you have to do the complete recruitment for filing this H1B.
That is what.
Yeah.
If the wage level is getting decreased, then anyone can file as a part-time cap.
Oh yeah. So that's what. If you plan it properly, you can do it.
Okay.
We file many H1Bs for part-time positions,
Okay.
but it has to be properly planned. So for example, if the wage is $30 per hour, they need to make sure that the, $30 per hour, 60K, right? If the wage is $60 per hour, right? Then make sure the person, like you mentioned, at least 20 hours per week. If you say 15 to 20 or 15 to 35, then then you have to do the recruitment. Okay, let's go through the next one.
Sir,
Huh.
like here. Here.
Oh, sorry.
Sir, there is an employee, like he is on H1B and now he got his GCEAD. So when we can run his payroll?
Whenever, so all you got to do, you can run his payroll whenever you want. Like as long as he's working, you have to run his payroll, right?
But we haven't withdrawn his H1B yet.
Huh?
We haven't withdrawn his H1B yet.
Okay, so the best thing to do in these cases is, once a person gets his GCAD, I highly recommend that you update your I-9 record to show that he moved to GCAD. Lot of employers are not doing that one. If they don't do it, then you're still held liable as per the H1B regulations. Once you move them to GCAD, withdraw their H1B.
Like he received his card on assumption as November. We run his November payroll on H1B.
Whether see, it's the same payroll whether you're running it on H1B or GCAD, right? There is no difference in that.
Like for H1B, we can pay in LCA wages. For GCAD, we can pay in hourly basis.
Okay, so that's why, if you are trying to make that change, make sure to clearly move them from H1B to GCAD. Document it.
Okay.
Document it. So how do you document it? You'll update the I-9 record,
Yeah.
right? You'll also inform USCIS that you asking them to terminate that H1B,
Okay.
right? So now the beneficiary can continue working for you using his GCEAD.
So is that a problem? Like if he's still running his payroll on H1B, like after
No,
receiving
no,
GCAD?
no, there's no problem with that. Because he can be maintaining his H1B status as long as he wants to, right?
Yeah. Thanks. That's it.
Thank you. Okay,
Sir, I
so
have a small
now we
question.
get to the important topic, which is collecting the money. How many of you have issues collecting money from your vendors? Good. You're having issues, okay. So whenever you sign an agreement with a vendor, what is the first thing that you need to do? Huh?
Payment and terms.
Payment and terms, okay. Okay, I'm going to give you an example. Okay, assume that I come up with a company called like Santosh Corporation, right? And I say that, hey, I'm going to enter into contract with you, supply all your resources to us, right? And then we enter into a contract. So what is the first thing? How do you do your due diligence? What kind of due diligence do you need to do? And this is one of the biggest mistakes that I see that a lot of accounts teams make. Huh? Forget about all that stuff. Reviews,
business
right? Okay.
practice.
How do you check the review? When you say review, you're right in a way, right? But how do you check? How do you get the proper information about that client? Huh? Glassdoor. Okay.
Best business practice.
Next.
US Visa Docs.
Hmm?
B- Best Business Bureau is there.
I'll tell you something. Typically, if a vendor stops paying one client, they'll stop paying other clients too. Right? That is what exactly happens. So the best thing for you to do is whenever they send you an agreement, right? So it will state the choice of law, venue, as well as their address, right? So for example, assume that the vendor is in some Maricopa County, Arizona. I'm just taking it for an example. The first thing that you need to do is go to Maricopa County court website. Okay, look up if anyone has filed any claims against that company in that courthouse. That is the best way to find out if this is a troublesome maker, if this vendor is a troublesome maker. Okay, similarly for employees also, if you want to make sure like you work for an employer who doesn't always go after the employees suing them, the first thing that I would do is if I were to be an employee, I would go and look at the county court website where the employee is located to see if the employer has filed any cases against the employees. Okay, does it make sense? If I come across an employer who has been filing cases against his employees like regularly, then I will not join that employer in the first place. Similarly, if I come across a vendor who has a lot of cases pending against them, I will not work with them. Yes, it will be available. You just need to do some research. Okay, and that is one of, like, for example, and then make sure that the agreement is reviewed as per that particular state law. Right? So when we are checking that one, we also check to see if there are any cases pending against that company. Right? Also, whenever you have a situation wherein you did not receive payment for more than once they violate, for example, if the payment term is 60 days, if you don't receive this thing, make sure to send them a demand letter through an attorney. Okay? Do not contact the client directly, because what happens is a lot of these vendors, they have clause in the agreement which states that you cannot contact the client for whatever reason, right? Whether it's payment or whatever. When you try to contact the client, then they will use it against you for damages, They'll say that, hey, because of you, yes, we're gonna pay you this money. That's separate, right? And then they'll have a liquidated damages clause for any damage that they have suffered. Now they'll say that, hey, since you reached out to the client, we are incurring damages, so we have to pay those damages. You cannot argue that, hey, since you did not pay, we reached out to the client. That doesn't make sense. Because if you argue that one, the court would say that if you did not receive the payment, then you should have proceeded against them legally. But you didn't have the right to contact the client regarding that. What's that? That's a problem. That's why initially itself I told you, right? Make sure you have an indemnification clause in the agreement and also inform the employee that you should not be doing that. Directly or indirectly.
Sir, let's say employee is working for the vendor and without the employer's knowledge, if he exits, like he resigns and doesn't want to work with the vendor, still employer has the flexibility to reach out to vendor and get the amount, right?
Of course, the employee has nothing to do with this. That's based on the agreement between the employer and the vendor. Okay, whether the employee is continuing to work for the employer or not doesn't make any difference. Since they have provided services, they have to get paid for that, period.
Okay, sir. Thank you.
You're welcome. Okay, so whenever you have a situation wherein you did not receive payments for, like, once the due date has passed, make sure to send them a demand letter. And also, periodically check the court website to see if they have stopped making payments to other vendors too. If they did that, then maybe you should just stop working with that vendor. Because usually what happens is, they'll say that you'll receive the payment for 2 months, 3 months. There are a lot of people who lost money because of this. Right? That's a problem. So even if the employee goes and talks to the client, right, they will sue you for that reason. That's a problem. There are a lot of employers who are going through this. And litigation, the problem with litigation is it's not about who is correct. Okay, it's about who has deep pockets to spend on attorney fees.
So what is the call? So what should we do? Example, I have a case, say, the vendor is not paying me from August, but I'm running my consultant payroll. So
if they're not paying you from August, then you have to send them a demand letter.
we already sent, but they're not replying to it.
Okay, where is the vendor based out of?
California.
Good. So in California, there is an option for the employee to go against the client also, client and vendor too. That's only applicable in California. So in California, if an employer is not paying, the employee can file case against the employer, the vendor, and the client also.
Yeah, my consultant has approached the client, but these vendor came to us saying that you are breaching the contract. We'll sue you. Same like how
So
you
you don't
said.
want to do that one. That's why you should send them a demand letter.
Yeah,
and
we
then,
already sent a demand
okay,
letter.
then you
but
should stop working with them, stop providing services to them, and then file a lawsuit in the court. Because if you reach out to the client, then he can have a claim against you.
yeah, thank you.
Go ahead.
Good afternoon, everyone, as well as Mr. Santosh. I'm Spanna and I'm representing Synersis here. So I have a quick question. In the agreement, if at all we had this clause that if at all they breach any clause, the agreement itself is null and void. Okay?
Typically, they will not allow that clause.
If at all, if at all it is allowed in that agreement, in that case, okay?
So you're saying that, okay. So you're saying that the agreement would have a clause stating that if one of the parties violates or breaches the contract, then the whole contract will be null and void.
Yes. So in that
Usually,
case,
no attorney would want, like, when for example, if I'm sending the contract to you, I would never allow that kind of clause in it, because typically what they would do is they'll say that, hey, even if one party breaches the agreement, it doesn't mean that the other party can breach it, because 99% of the times the vendor will be breaching it because they will not be paying you on time,
yes.
right? So once they know that once they don't pay you on time, that's a breach of contract, and that you would just you'll breach the non-association non-compete clause too.
Exactly. So if at all that clause is involved, then we can go
Well,
ahead
yeah,
and do that.
if you can get that clause into the agreement, yes, you can do that.
Okay, sounds good.
But
And
usually, none of the vendors would allow that.
and there is another alternate option which I come up with. Can we confirm them through the mail officially that since there is no response from your end and you leave us no chance but to approach the client and take it officially,
No.
we are giving the
No.
notice?
No. You have a choice. There is no this thing of not having a choice, because you have the choice of suing them in the court and getting the money.
So the only option is to have a clause which is involved that it is
Yes.
mutually applicable for both
Yes,
parties.
yes. Or have a clause in the in the agreement stating that they would allow you to actually reach out to the client in case of the payment delays.
Failure of
But typically, they would not allow that to be there.
Thank you.
You're welcome.
What are the major points we have to check in MSA before signing the contract with vendor?
Good. If it's a vendor contract, okay. Who has bigger chance of suing the other party in a vendor contract?
Vendor. Obviously, it's their MSA, so they have more authority.
No, not the authority. Who has more chances? So the vendor can sue you only if there is a breach of non-comp and non-solicitation clause, right? But typically, you would be suing them if they don't pay you, right? So depending on because that's when the contract will actually get into picture, right? Either the vendor did not pay, or you breached a non-solicitation non-compete clause, right? So depending on that situation, you have to see whether arbitration is a better option or being able to file in the court is a better option. That's one thing that you have to look at. You have to look at the state laws and the payment terms, and also any clauses that will unduly restrict your ability to collect money from them. Actually, there are a lot more things that you could actually look into. But if you send me an email, I'll provide you that information.
Sure.
Yeah. Because I want to get to the H-1B modernization rules, the Trump administration, because I know we have very little time, right? Yeah. Next. I think I already went through the ability to pay for GC cases. Sure. Okay. So if you are sponsoring any green card applications, please do not show losses. Please do not show losses. I recommend that at least showing some profit, unless you are a very big company with more than 100 employees. Okay? Accrual cash basis, I don't think it's required. Let's merger sale. Okay, so make sure, like, if you want to get the best value for your company, I highly recommend that you audit your books from time to time, not only like your accounts, but also the legal, like for all your legal compliance too. I think it's okay. We'll just move on to the next. No, go to the H-1B modernization. Okay, so how many of you are familiar with the H-1B modernization rules? Good, 1, 2. Anyone else? Okay, I highly recommend that you all read those regulations. It's very important because they are gonna go into effect Jan 17th. Okay, even if the Trump administration wants to make any changes to that one, they cannot do it for the next at least 1.5 to 2 years, because they have to go through the regulatory process and all that stuff. Or I don't think they'll be doing it through the legislative process. So these regulations will stand for the next 2 years at least. Okay, so it's very important that you have a clear understanding about the new H-1B modernization rules. Okay, So these regulations will go into effect on Jan 17th. So any petition that you file after Jan 17th, they will be reviewed as per these regulations. But recently we have been, or we already been seeing some RFEs issued based on these regulations, although these did not go into effect. That was correct. So these regulations primarily affect H-1B workers, but apart from H-1B workers, it does affect other visa holders also, like H-2Bs, TNs, E3s, and all other non-immigrant workers too. So in this one, let's go to the CAP registration process. Okay, so the CAP registration process pretty much stays the same as it did last time, which is beneficiary centric. So no matter how many number of employers file H-1B CAP registration, it will be selected as only one slot, right? And also in this one, they clearly mention, like, so even if multiple employers submit CAP registration on behalf of the same employee, right? I think you have been receiving a lot of noise on that one, right? Actually, as long as you can prove that these are for separate bona fide job offers, it is fine. Okay, that's still it's called matter of S. You could actually look it up online, wherein the court has clearly mentioned that as long as they have separate bona fide job offers, you should be fine. But proving that you have separate bona fide job offers will be a challenge if these are rated companies. Okay, so I highly recommend that you do not submit multiple registrations through different companies. Is that clear? Does anyone have questions on the H-1B CAP registration process?
So when you said related, it means like there should not be any MSA in between those companies as
Not
well?
MSA, well, even if they, yeah, MSA also we could say that, for example, assume that your company ABC Corp, and then you worked with a vendor, maybe like small vendor, right? Some smaller consultancy firm. And then you got the H-1B, both of them filed the CAP registration, and then you use them as a vendor. Yes, it shows like as if both of you are filing for the same position. That's a red flag, right? But what is the advantage that you're getting by submitting multiple registrations in this case? There's no advantage, right? So stick with submitting one registration for the candidate. Okay. Also, the H-1B CAP period need not start from October 1st. We are all familiar with that, right? The same thing as last year. The next one is expansion of CAP. Okay, CAP gap rules. So usually CAP gap is allowed only until October 1st, right? Until September 30th. So if a person has a pending H-1B petition, CAP H-1B petition with USCIS, and if they have requested for a change of status, the person can continue working using CAP gap OPT until September 30th, right? Now they are allowed, because of the delays in H-1B processing time and all that stuff, they're allowing them to get CAP gap OPT until April 1st of next year. So that will allow a person to continue working for much longer time using their CAP gap. This is one important thing. Now under this, they're gonna give deference to the previous approvals. So if you have a H-1B that is already approved, and if you're filing for an extension with no material changes, right, they have to give deference to the old approvals. During the Trump administration, they actually changed it, right? So they mentioned that they will not be giving any deference to the old approvals. But now in this one, they clearly mentioned that deference will be given to the old approvals as long as it was not approved by mistake. So now we can expect a little more consistency. So elimination of itinerary of services. Now you no longer need to provide itinerary of services. So non-speculative bona fide employment. This is where the challenge is going to start. So now, until now, you could get H-1B approvals even without providing an MSA, purchase order, client letter, anything, right? But with this one, now you're required to prove that you have a bona fide job offer available for the candidate. That means you have to show that there is non-speculative employment available for the candidate. So you'll have to provide MSA, vendor letter, MSA, purchase order, vendor letter, or whatever is needed to prove that the work exists for the candidate. Okay, so it's like just going back to the old times wherein you're required to provide all these documents. Not only that, whenever you have a third-party placement, in order to prove that position qualifies for specialty occupation, right? The job requirements have to come from the client. So basically, they're asking you to provide the client letter, right? Or something from the client to show that these are the requirements from the client. So here you'll be encountering two challenges. One is, most of the clients, they will not mention that the position requires a bachelor's degree, right? Even if they mention bachelor's degree, they will not mention which field they needed, right? They will not mention that bachelor's degree in computer science is needed. Assume that they mention that also. Along with that, they'll also mention that the position requires 5 years of experience. So once they mention that the position requires 5 years of experience, now you're providing that information to the government, right? So they will want you to pay level 4 wage or whatever. Okay, so basically we're going to go back to the old times wherein we need to provide the client letter, the vendor letter, or MSA and purchase order. That will be the biggest challenge. The next thing is with FDNS visit. As I mentioned initially, right, until now, if FDNS visit is, compliance with FDNS visit is voluntary, right? But now they're going to make this mandatory, wherein if there is an FDNS officer who visits your office, and then if they want to get some information, you have to provide that. If you don't provide that one, they can withdraw the H-1B or deny the petition. So this is another challenge that you'll be facing under this one. Redefining specialty occupation, actually they have slightly modified the definition of what qualifies for specialty occupation. I don't know if it's worth going through that now, but the most important thing is that for third-party placement, they want the position requirements to come from the client. Does anyone have questions regarding this?
So,
inclined. So if you're placing a candidate at Apple, they want the position requirements to come from Apple. That is going to be a problem. Yeah.
So when we speak about gap rules for an OPT consultant, as you say that until April 1st, he need not required to do change, right? Because we have already applied for his H-1B nomination. What if it is getting expired before the nominations? I mean to say, he need to file for his extension or not? OPT extension is required or not?
I didn't quite understand the question.
Gap rules, sir. When we speak about gap rules, until April 1st, the candidate can be on OPT, right?
Yeah.
His H-1B is submitted.
Yes.
Because he has to wait to get the approval. I just want to understand before 30 September if his OPT is getting expired. In this case, does he need to apply for extension or it's not required because
No, he will get the cap. They will provide the cap.
Oh, no need to file for extension, right? Thanks, sir.
Sir, now in this coming administration, does ITSO memo going to sustain or it's going to be into trash?
Well, with these modernization rules, it's already in trash, right? Because except for the right of control, right, and the 3-year H-1B approval note period, right? Now they have to prove that there is a bona fide job offer, non-speculative employment. The client letter requirement is going to again start. It's going to be a challenge.
Got it, sir. Thank you.
Thank you.
So these regulations will affect after Jan 17th filings or like the one which we filed before as well?
Usually it should go into effect after Jan 17th.
Okay, after Jan 17th. And do we have any changes for amendments as well? Like from day one, we have to file the change of location or the
It
pay?
remains the same.
It's the same, right? Thank you.
I think so. Yeah, I don't have. I think they already updated the registration fees. They have increased the registration fees. I don't know the exact number, but it's 200 and 215. Yeah, it's 215. Any other questions? So now tell me how many of you think that the business is going to thrive during the Trump era? Good. That's true. So we could have issues with the wage levels, right? Maybe he'll ask, they might come back and say that, hey, you need to pay higher wages. But based on the recent news, it looks like it's going to be favorable for the H&B workers. So the business is going to be good. But of course, the laws will be implemented more strictly now. So you can expect more FDNS visit, more RFEs, okay? Even denials could happen, but still you will be able to run your business. What's that? Yeah.
So I have one doubt. For a person who is working in hybrid with the client place, and what if he's not in the office if an officer comes as a site visit?
That's not a problem as long as you could, the officer is able to reach you, and if you can tell them that, hey, I work my work involves hybrid, right? And then you're working from home on that day, that's perfectly fine.
If a person is working remotely, like 100% remote job, where does he need to post the job postings?
Wherever he's working from. So if he's working
At
from
his
home,
home.
he'll just post it at his home.
Like onto the door, onto the main door, or the workplace, or where exactly? Like
On his refrigerator.
Like normally, if a case gets approved in the consular processing, should he need to travel out of the country, get his go for the stamping and come back to the US, or?
Not necessarily, they don't have to do it immediately, right? If they already have a valid visa, or like for example, the person is already on OPT, he can continue working on OPT, and whenever he wants to get back to H1B, he can either go for stamping, right? Or he can file for another H1B with change of status.
Oh, without even working on this H1B,
Yeah,
can he
they
work?
can do that.
Can he change for file for a change of status?
Yeah. But there is a risk here, right? So for example, if once H1 petition gets approved, right, there could be a site visit at any point of time.
Okay.
Right? If the person is actually not working in that position, then they might withdraw the H1B, right?
Okay.
And if the officer doubts that the position did not even exist at the time of filing the position, then they may withdraw it for fraud or misrepresentation. If a petition is revoked for fraud or misrepresentation, then the cap number will be recaptured. So the person will have to go through the H1B cap process again.
Okay. Okay. Yeah. Got it. For the consular processing, should he go to the home country, or just out of the any
not
other
necessary, but home country is always better.
Better. Okay.
Good. Any questions? I know it's. We still have
Can
more minutes.
one question
2
on behalf
Yeah.
of many companies. One of the major election promise Trump has made is anyone with a US master degree will get a green card. So do you think that is possible?
It's not technically possible because the number of visas that are the green cards can be issued is limited to 140,000, right? And over that we have the per country limit and everything. So it's not possible to issue green cards for everybody who has a master's degree. But they might come up with a procedure, like for example, EB1 category or something like that, so that people who graduate from top universities could be eligible for that one. That's one way of doing it, but I don't think he's going to give green cards to everybody. That's not practically possible.
Thank you,
So on
sir.
one hand, we're talking about people getting green cards. Other hand, we're talking about people not getting even OPTs, which doesn't make sense, right?
Yeah. And one more commonly asked question is, lot of the firms and there is a lot of panic in the market about traveling before January 20th or immigration related panic after January 20th. How do you see this?
I would not worry about it too much. I know everybody is talking about, everybody's panicking, but it can't last. Like whatever that decision that he's going to take, it has to be probably staying for 5 years, right? And I don't think it's practically possible for anyone to stop traveling for 5 years. Of course, since we don't know what kind of restrictions will be there, it's better to avoid traveling after Jan 20th for a few days to see what kind of decisions they would make. But for H1B workers, as long as you have a proper job, everything is proper, I don't see a problem. The same thing applies to students also. As long as they are not violating their status, they're studying properly and everything, I don't see a problem.
Thank you, sir. One more question. During the last term of Trump, we have seen several travel bans imposed on specific countries. So would that
That
repeat
could be
again?
there.
Yeah.
Because that's part of the executive action, right? So, yeah.
So
he can do whatever. Like, yeah, that's.
Do you foresee a faster progress in the movement of employment-based immigration numbers due to a drift travel bans from family-based immigration?
Well, if they make it a little tougher for the family-based immigration, then definitely yes, it's going to be helpful for the employment-based, right? So, like during last time also during COVID, right? A lot of embassies were closed, so they were not issuing GCs, family-based GCs. That's why there was a huge overflow of family-based green cards from family-based to employment-based. That's why a lot of people got their green cards, employment-based green cards.
Okay, sir. And how is it going to be at the consulates? Like we have seen a lot of 221Gs since the last few months.
That will be there. So we can expect more 221Gs, more scrutiny. Okay, but as long as you are maintaining the person is maintaining his status and there is no fraud involved, they should not be worried about it too much.
Okay, sir. Thank you.
So actually, there was one scenario with one of the consultant. He was having in valid H1B. He traveled to India because of some emergency, and he was in India. When he traveled for stamping, he got to know that his H1B was revoked. When he inquired with his employer, did his employer withdrawn the petition? Then the employer said that the H1B was never withdrawn, and the reason he got to know that before that he has applied for multiple registrations, and because of which his H1B was revoked. So I just want to understand.
His H1B would not have been revoked without the employer knowing about it. The employer would have received a notice of intent to revoke before they revoke the H1B.
So it is not an impact of multiple registration, right?
No. Even if it's because of the multiple registration, the employer would typically receive a notice of intent to revoke, and they will give him the opportunity to respond to that one.
So coming forward, we can expect that the people who applied for multiple registration.
Oh, that has already been there. Like a lot of people who submitted multiple registrations, they're receiving notice of intent to deny, and the petitions have been revoked. So if it is revoked for this reason, then the cap number will also be recaptured. So they cannot file a H1B transfer to another employer. They have to go through the cap process again.
Again, they have to apply
Yes.
for lottery process,
Yes.
right? Okay, thank you, sir.
You're welcome.
Sir, in the recent times, we have filed few cases on our own personal projects, which we have at our own office. And we see the cases which are not being approved in spite of having our own genuine projects. And what exactly could that be the reasons? We see without any reason
Because
we
of
get
all
that
the
point.
fraud that's happening here.
No,
Okay.
there was all a genuine project. Everything was all on set, and we had everything that could be shown.
Okay. So typically, there is a red flag whenever an employer moves the employee from the in-house project to a client location as soon as they enter into the US. Right? I don't know if you had similar kind of a site visit, and if they have realized that the employer is actually moving the candidates as soon as from the in-house project to the client location as soon as they enter into the country, or if nobody is working on those projects, then yes, there could be any issues in getting visas for those positions.
We used to do, but not very soon, but maybe an year or so. Would that
Year or
still
so did you file H1Bs for that 1 year period, or did you file it for 3 year period and
3 year
then?
period?
That's a problem, right? That's what I was telling you. If you believe that you have the work available for only 6 months, file the H1B for 6 months. Right?
Okay,
That means you've been truthful to the officer. But if you're saying that you have project for 3 years and then just automatically changing it, moving them to different clients, then it's a problem.
Okay.
At port of entry, after Jan 17, do they ask for client letter for the new travelers, by any chance?
They may not ask for the client letter, but they will ask for the employment verification letter. Okay, and they might also verify, sometimes they may call the client to verify they actually have a project too. It is possible, but it's very rare.
Okay. Because if we keep like either in-house or then they might be asking for only employer.
They'll have more strict scrutiny, they'll scrutinize them more.
So in this case, like it's
usually the officer at the CBP level, he will not have access to the petition, unlike the officer at the visa consulate.
Okay. Thank you.
Good. Any other questions? Good. Thank you all for attending this event. Thank you, Raghav. I hope it was informational, and thank you for spending time over the weekend with us. And if you have any further questions, please let us know, and we'll be happy to help. Is there anything else you want to? Oh, you want to take more Q&As? I don't know how long is, like, it's 4 o'clock, right? Oh, you have time? Okay, good.
Can I?
Good, go ahead.
Yeah.
It's okay. I don't know, I'm feeling a little bit of sore throat, but that's it. Uh-huh. Online filing. Huh.
Can you just say something more about that as well?
Okay, so I think one of our employees can speak better about the online filing because they do it. Can someone go speak about it? It's pretty simple, right? It's actually better to do online filing because you're able to get the receipt notice immediately, and then you have better tracking and all that stuff. And approvals are also coming much quickly if you file it through online portal.
Sir, this is such an informative session since morning. You have been standing and sharing all the knowledge. What is the outcome? Is there any way that we can utilize your services, or somewhere we can reach out to your desk?
Definitely. The best way to reach out to us is by emailing us. Our email address is info@somireddy.com, info@somireddy.com, or some of our team members are here. You can contact them. They'll be able to get you in touch with us.
Sir, I would highly recommend you to take another same kind of session after 6 months, probably in July, so we can have more questions.
I'm planning to do one right before the cap reach, because by then the Trump administration is going to go into office. Like we'll have a better idea in the next 1.5 month. In the next 1.5 month, we'll have a better idea. But at that time, I'll probably do a session just on immigration, because right now the topics that I've covered are more applicable in general, right? Whether it's Trump administration, Biden administration, whoever it is in office, right? So the next session would be more specific to just H1Bs and green card processing, just primarily immigration.
First of all,
yeah, well, we are actually moving our office here. So until that construction is completed, I'll have to be here for the next 2 months. Yeah. Yes, we'll plan for that one.
I would like to give thank note here, Mr. Santosh here. I think this is the first session in Hyderabad. An immigration attorney is conducting this kind of session. So, for, yeah, we are thanks. I mean, like, thank you so much.
Thank you.
Yes. Uh, can I go ahead? Next. Yes. So can you brief a little bit on the counselor H1 too? The checklist that which has to follow or any trigger points that we need to follow?
Good. First thing is make sure before your employee goes for H1B stamping, right? They have to thoroughly review the LCA, review the support like the I-129 form and the support letter itinerary services. Lot of times employees go attend visa stamping without even knowing about the information that's presented in the petition, right? So it's very important that you not only give them a copy of the LCA, but also provide them with the itinerary of services, the job duties that they'll be performing, the the project that they'll be working on, all that stuff. Okay? Because typically the officers make a decision within a few seconds. As long as they can see that whatever the information that the beneficiary is presenting matches with the information in the petition, there is a high chance of getting visa approval.
I do have few more to go ahead,
Sure.
if you don't mind.
Yeah.
So initially we have discussed about the RTR clause and all that needs to be taken from the candidate, including exclusivity as well, right? So it's not mandatory that the candidate whom we are going to submit, it's supposed to be only for one client. It could be multiple clients too. So each and
So
every
if you have it for multiple clients, make sure you have it for multiple clients.
Okay.
Okay? It's very important.
So is there
Because if, for example, if you take my resume and if you say that I'm going to submit to clients, I'll be working with multiple employers, right?
not the employers, but the clients that we have the position, we can submit one
That is
single
true.
candidate.
I highly recommend that you clearly mention who the client would be.
Is there a chance where we can bind them with the exclusivity clause that certain period you are
You
not
cannot
supposed
bind them with exclusivity clause for any client that their employee is not aware of, right? If you're binding in that way, then you have to at least put them on wage because now their life is restricted.
And also what
If they are your employee, yes, you can probably do that, but not for someone who is just applying for a job.
and what about the fines or any clauses that would be applicable to us through the vendor or client? Can we pass on the same clauses to the candidates as well in the agreement?
You can do that.
That also includes a level of fine amount in it
Yeah.
still?
Yeah.
And
That's indemnification clause.
do we have any certain limit for that fines or penalties that's supposed to be?
Best thing to do is just put in indemnification clause stating that, hey, whatever the damages that the company incurs because of the beneficiary's action will be transferred to the beneficiary. Just put in indemnification clause, that will solve the issue. You don't have to mention any specific amount for that.
Got it. And also you mentioned that we cannot bind a California candidate, whoever is working or who is actually employed there. So
Well, in
what the
California, you
alternate-
cannot use the non-compete clauses against the employee.
What could be the alternate option that we can able to possibly look at?
It's tough.
It's done.
Yeah. If an employee comes to me saying that, hey, Santosh, I'm working for so-and-so client, now I want to breach this non-compete, non-association clause, what do? And if I can clearly tell them, hey, move to California, make sure to inform your employer about it. And if they file an amendment, that means they are attesting to the fact that you are actually a resident of California. And now you can just move on.
And how far can we accept a digital signature for any agreements?
That's
that we
perfectly
done
fine.
with?
Digital is fine.
Do we have to maintain anything as comparing with the ink signature or something, or it
Not
could-
necessarily. It's so when you have the if you're using, I assume that you're using Adobe Signature and all, right? You should be fine with that.
And also, how far can we go to legal aspects when we have to deal with any candidate about the payments or anything?
You could send them a demand letter, or if you can file a case against them. But I highly recommend try to avoid going after the employees as much as possible, because you're going after a small fish.
And how
Right?
highly
At the same time, yes, everybody has to do your business. You have to do your business, but keep it reasonable.
and how highly do you recommend to take the H1B candidates after all these changes in the next
I
year?
highly recommend taking H1B candidates.
Thank
If
you.
you're not able to find a US worker,
Got it.
right?
Thank you.
Because if you are able to find a talented person who is only on H1B, then you don't have an option.
And is there any chance of way we can able to revoke someone's background check after getting it done? If at all there is few issues that goes on with the candidate?
Yeah, if because it's all at will employment, right? You can always fire the employee for any reason or no reason. Right? But once you file a H1B, then you're kind of stuck. You have to properly terminate the candidate.
Not for the H1, but I'm referring to the background check. Can
Yeah.
we give an intimation to the client or vendor that this candidate has falsely given the information about his employment or anything to do with our company?
The problem here is the employee, the person can have a claim against you if that information that whatever you're providing is incorrect.
Okay.
Right? So you have to be very careful when doing that.
Yeah. Thank you.
That's why even if somebody leaves your company, right, and if somebody is calling to get a verification letter, they would they would not ask you whether you how is this person. Instead, they would probably ask you, are you willing to rehire this person in future? So if you say no, that means there is something wrong with the candidate.
So for this cap, for this new cap, is there any change in fees for registration at the same time H1?
Yes. We just talked about it, right? I think they are increasing it to $250 for the cap registration.
250 for the registration. And what about the filing fees?
The filing fees will remain the same, whatever is the current filing fees.
Okay.
They already increased it recently, right?
Sure, thank you.
Sir.
Yeah.
Madhu. Sir, for example, we just started the company in US. We do not have any tax returns or anything done. And we have like 5 or 6 H1 spent. How do we prove our financials, or what are the complications as an employer we might have to face?
Good. First thing, if you're H1B employer, right, you need to show that there is some supervisor in the company, right? There should be at least 1 or 2 employees in the company. I recommend having at least 1 or 2 employees in the company before you start filing H1Bs. Okay, one of the employee could be the president of the company. That's perfectly fine. And then also, now you're stating that you'll be paying maybe 100K or whatever to the candidate, right? So you need to show that you have the ability to pay that one. So if you already have been in business for quite some time, if you have generated at least 100 200K in revenues, then it's clearly evident, right? Along with that, we'll also provide the MSA purchase order to show that there is actually work available for the candidate and that you will be generating enough income to pay him, right? So typically, I recommend that you have at least 200K or 50K in revenues and 2 employees before you start filing any H1Bs.
One more question. Can the signing authority be out of the US, like, in subsidiary company, for example, in India?
As long as they are authorized by the company board owners. So now they're going to go after the owners of the company.
Okay. Yeah, thank you, sir.
Okay?
Thank you for this
and
opportunity.
Also, please be aware, now the government is requiring everybody to provide the beneficiary ownership information for all the companies. Because it's a different entity, right? The entity filing the H1B is the US entity, which is separate from the Indian entity. No. So you usually, okay, if you do not have, because some of the companies will not have revenues, right? But they will at least have some assets. For example, if it's a startup, right? Or maybe you're building some product and all that stuff, you will not have revenues. But at least you will have some assets or some money in the bank. That is fine. So if you have, but in these cases, it's little tough. But if you have a project, if you can clearly document that you have been working with the client for quite some time and that you have regular work available for the candidate, then you can make it work. Okay. Well, see, H1B is for a special occupation position, right? So what you're asking me is for that the person would more qualify for an L1A, right? L1, you could probably try L1A new office. That's the best option.
Hi Santosh, very good evening.
Hi.
So when it comes to concurrent H1 here,
Who is asking? I'm sorry.
here.
Oh yeah.
So I'm an employee. I'm an employee
It's okay.
working for ADP, and I want to go with an employer. Suppose filing concurrent H1, and I want to work for another client. So will I have to intimate ADP people that I'm going to file a concurrent H1? I
That
may be
depends
work.
upon your contractual agreement, which is the employment agreement,
Okay.
right? So if your employment agreement has any restriction, then you have to abide by that.
Okay.
Usually ADP would have it, at least in your employee handbook. You will have a moonlighting clause.
Okay. So when we are filing LCAs, so we have to go back and check the travel histories of travel to other countries, right? So up to what time frame we have to check? Like,
LCA?
like so amendments.
You don't have to look at the travel history for that.
Okay.
Well, say, are you asking me about the travel history, like when he, like in and out of US?
Yes.
Yeah, usually, so for example, usually for 6 years, okay, but if you are trying to recapture any time that the person, for example, in order to meet the 6-year requirement, then you may have to provide more information.
Okay. So I'm an employer. I have my employee working for full time. Can I pay him on part-time basis?
No.
No. No way. Okay. Thank you so
You can
much.
pay him, but he can come back and sue you.
Okay. It's if it is an on records also, off records also.
Doesn't matter.
Okay.
Okay, because there is something called circumstantial evidence.
Okay.
They'll be able to get some evidence.
Okay. Thank you so much.
You're welcome. Because you'll be submitting client these timesheets to the client, right? Stating that this person has worked 40 hours. Yeah.
Yeah, Santosh, I just have a small question. For concurrent H1B, right? We have, if I am an employee, H1B full time, and parallelly, concurrent H1B has been filed with another employer. So in US, does it not fall under the dual employment, or it is
Dual
okay?
employment is perfectly fine.
Okay, perfectly fine. Actually, in India, we don't allow dual employment, right? So I was asking, in US, it is okay.
I didn't know that dual employment is not allowed in India.
Yeah, like two payrolls cannot be run on single entity, Santosh.
Okay. I'm sorry, but I don't know about the regulations here.
Yeah. So
I mean,
there is
she's
no
asking,
issue of dual employment,
can he
right?
work for 2 employers and 2 roles?
Yeah, as long as you're authorized to work, you should
We
be
are
fine.
not allowed here to work for two employers
2 employers.
in India.
Then how do people do moonlighting here?
Again, it depends on the company, for the organization that we are working.
Okay.
Suppose in India they work for 2 companies. In Corona time they work for 2 companies, 2 jobs. Like in US, can he do for 2 companies? So he will get 2 W2s or how?
Yeah, he'll get 2 W2s. He will receive 2 W2s.
2 W2s. No issues, right? No, it's not an
no
illegal.
issues.
Okay.
He could be receiving more W2s if he moved his employers during that year also, right?
Yes, yes.
That's
And
perfectly
Santosh, one more thing. Suppose I-7 is valid some more than 6 months, but I-94 is getting now. So how can we extend the I-7, 97 or I-94 now? Any possibility to extend
To
I-94?
extend H1B I-94, right? You have to file H1B. If you're trying to extend the H1B I-94, you have to file a H1B petition.
So filing I-94 is mandatory.
No.
extension.
Sir, this is out of gratitude. Thank you for taking care of us from morning to till this time. He provided everything free, and we have to be thankful. In this world, nothing is free, but you made everything is free. May God bless you, your team, and may God expand you. Thank you very much, sir.
Thank you. Should we conclude? Okay.
To add on to the dual employment, I'm talking. So I'm talking. I'm here. Here.
Oh, I'm sorry.
Okay. To add on to the dual employment, it is allowed in India. Only thing is, the hours should not clash. That means if I'm working in an office from 9 to 6, after 6 to 10, I can work in another office. That is fairly taken care.
Good. So
yeah, that is allowed.
Here you're not allowed to work, like you're not allowed to spend 9 to 6 in one office and while in this office work for some other company then.
Yeah.
That's good.
It is allowed because mainly accountants, they take this dual employment. They work full time in an MNC. As a part time, they work with other companies. If going evening at 6 o'clock, 7 o'clock, working until 10:30 tonight, and they get their expenses.
Good. Thank you. For,
We can take few more questions. Any immigration related questions or litigation related questions? We're left with 10 more minutes, sir. We can take a couple questions. Anyone? You can raise your hand.
I think they want to do something else, right? Raffle or something? No, I'm fine. No, don't worry about
it. Yeah, okay.
Anything else?
One question. Hello. Yeah, what will be the timeline process for 221G administrative processing?
There is no timeline. Who is asking me that question? Unfortunately, there is no timeline.
Okay, but
because we have seen cases that have been pending for under 221G for almost a year also. We could raise requests, like sometimes raising requests to a congressman or senator would help, when sending an email would help, but they come back and say that, hey, you're conducting a background check. For background check, they would not give any proper timeline.
If filing in process from India, so in-house filing, so what should be if the officer asks for client letter if we don't
they
have
will
client
not,
letter?
you can clearly mention that it's an in-house project.
So still in-house project mentioned, but they're asking for client letter. How to avoid
you have to clearly,
221G?
no, they cannot ask for that. You can clearly mention that it's an in-house project and these are your clients for the project. Or if it's in the initial phase, then you can say that, hey, we don't have any clients right now, but these are the potential clients.
Okay.
Okay. Okay.
Sir, actually there's a small game of raffle. Everyone has ID cards, right? You'll having your last 3 numbers, like 001, 002, like that. So we'll have 3 winners. Sir, you only pick it up. That's random.
I didn't check my...
You don't have that. You don't have that.
Okay, 167.
167.
Is he? He's not there?
If you got a number, you can stand up actually. That way we can identify you.
232.
232. Okay, congratulations. Please come here.
Please come.
Your name, please.
A little cheering.
So my name is Sayed and I'm from Response Informatics Limited. I am a BDM and I've been working from past 5 years. And really it was very helpful session for me because I've learned a lot of things related to human resources of immigration type. And I really appreciate your efforts. And there is a lot of things that came new into picture. It will really help us for the upcoming H1B process. And as you have already mentioned that soon we are going to have a new session coming up after the H1B become and all. So I hope I will be attending that as well. Thank you so much.
Shayad, please pick your gift.
Before that, please scan the QR code, Ritik.
$182.
182.
182 available in the hall. Okay. He's there. He's coming.
I think this is one way of checking if people are really interested in this session and ended up staying here until the end of the session, right? If he was not there, then I would have thought that only 50% of the people liked it.
Yeah, hi, good evening everyone. Myself Zach, I'm from Into First Technology. I'm a admin HR, so yeah, the session was very nice and we learned a lot of things today too, from our nation, how things gonna be happen here, immigration, this coming future forwards. Yeah, thank you very much.
Thank you.
One girl, okay. 129.
129.
Please check your numbers thoroughly, please. 129.
Good. We got another mail.
Good. So based on this, I can say that we have at least 75% success rate, right? Out of 4 people, 3 people ended up staying until the end. That's good.
Yeah, my name is Saichan. I'm from Synersis Technologies. I have 3+ years of experience as an immigration specialist. Really, this session helped me a lot of things, and I hope it will be helpful to upcoming immigration process and filings. Thank you, sir.
Thank you, Saichan.
Thank you.
Thank you, sir.
Thank you everyone for attending today's seminar. We have a tea break actually. So we have a high tea, have it and then we will assemble back. Oh, anyone want to personally interact at Mr.Santosh, you can talk to him. Yeah, we also need a video testimony.
No more presentation. I'll just sit there and talk. If it's okay with you guys. I'm already exhausted. Maybe it's because of the jet lag or whatever.
Yeah. Also, we need a group picture. So.
And also, I would like to thank all our team members for arranging this. You guys did a fabulous job. Actually, I did not do anything to arrange this one. Frankly speaking, It was all done by the team. Padmaja, Sandeep, Shrikant, Hari, everybody, Ishika, everyone. You guys did a wonderful job.
Gopal.
Gopal, of course, Gopal. Yes, yes, yes,
Group
yes,
picture
yes,
is
yes.
Actually, we're going to call everyone here so we can have a group picture.
Please.
Thank you.
Oh, okay.
Logo.
Short period, but for those who are poor and deprived sections of the community, even 50 days torture can bring about disastrous effects.
A visionary economist, a statesman, an architect of economic reforms in the country, India bid farewell to one of its most respected leaders on December 26th, Dr. Manmohan Singh. Born on September 26, 1932, in Garh, Punjab, Pakistan, Singh's journey from a young economist to the highest office in India was nothing short of extraordinary. A brilliant scholar, Dr. Singh earned his master's degree in economics from Punjab University, Chandigarh, and went on to complete his doctorate from the prestigious University of Oxford. His career in public service began in 1971 during the Indira Gandhi government as an economic advisor to the Ministry of Foreign Trade. Over the next few decades, he held several critical positions, including Chief Economic Advisor, Director of the Reserve Bank of India, and Secretary of Economic Affairs. He played pivotal roles in India's economic policy at a time when the country faced immense challenges. After Indira Gandhi's assassination, when Rajiv Gandhi became the Prime Minister, he appointed Singh as the Deputy Chairman, Planning Commission, where he served from January 1985 to July 1987. But it was as Finance Minister in 1991, during India's most significant economic crisis, that Dr. Singh became a household name. Appointed by Prime Minister P.V. Narasimha Rao, he initiated bold reforms that transformed India's economic landscape, ushering in liberalization, devaluation of the rupee, and foreign investment. His visionary policies reshaped the Indian economy and positioned the country on the global stage.
When I took over, were no more than $1 billion. That is roughly equal to 2 weeks imports.
Dr. Manmohan Singh served as the 14th Prime Minister of India and was sworn in as the Prime Minister on May 22, 2004. He remained in office for 2 consecutive terms till May 26, 2014. A Congress leader from the Sikh community, Singh also became the first Prime Minister of the country from a minority community. Heading the Congress-led United Progressive Alliance government for a total of 3,656 days, Singh thus became the third longest-serving Prime Minister till date after Jawaharlal Nehru and Indira Gandhi.
So let's give a great applause. It is very sad to lose such a great economic reformist for India. Now we'll pay tribute to Mr. Ratan Tata and we'll have an AV and then we'll have a 2-minute standing ovation for them for what they have taught us, and we'll discuss a little more about them after this AV. AV, please.
The year was 1962 when a young man of 25 entered the offices of the National Radio and Electronics Company Limited at Andheri in Mumbai. 9 years later, he was the director in charge of the company, and a decade later, the chairman of Tata Industries. In 1991, he succeeded J.R.D. Tata as the chairman of the Tata Group. The youth was Ratan Tata, fresh out of Cornell University, armed with a bachelor's degree in architecture, more than ready to enter and learn as he would rise from the lowest rungs in one of India's most hallowed industrial houses. Today, Tata's contribution to India's largest conglomerate and to the nation's economy was second to none. He was on a pedestal very few industrialists in the country were able to climb. Though he had the magic surname, young Ratan had a tough act to follow, that of his predecessors Jamsetji Tata, Dorab Tata, and finally the iconic JRD. Ratan Tata took on the challenge, and by the time he retired in December 2012, the Tata Group's financials spoke loud about the impact he had. During his tenure, the group's revenues grew manifold, totaling over $100 billion in 2011-2012.
Been recognized all over the world as an enterprising country.
Ratan Tata identified the opportunity which the liberalization of the Indian economy provided and began restructuring the Tata Group in 1991. Under his leadership, the group acquired high-profile international brands like Tetley Tea, Daewoo, Chorus Steel and Jaguar Land Rover. He was also the man behind Tata Nano, the company's small car project, which he hoped would give wheels to the middle class. The journey, however, was not easy and tested his mettle at every turn. First, he had to deal with the satraps, a legacy left by his uncle JRD Tata. Rusi Modi lorded over Tata Steel. Darbari Seth was the final voice at Tata Tea and Tata Chemicals. Ajit Kerkar was the force behind Indian Hotels. And Nani Palkhiwala was the man behind ACC. Each considered these companies their fiefdoms and looked at Ratan Tata as another outsider they had to deal with. 6 years after taking over as the Tata Group chairman, all four of them had resigned. Ratan also wielded the broom on several companies. He exited cement, textiles and cosmetics and focused his energies on software, telecom, finance and retail. Finally, after serving as group chairman for 21 years, Ratan Tata retired in December 2012. He had spent 50 illustrious years with the Tata Group. An avid aviator, Tata was awarded the Padma Vibhushan, the country's second highest civilian honor, by the Government of India in 2008. The humble, reclusive industrialist was also known for his philanthropic work. Till his death, he served as the chairman of the Tata Trusts, which are amongst India's oldest non-sectarian philanthropic organizations that work in several areas of community development. The proudest moment for him, perhaps, in recent years was bringing Air India back home to the Tata fold, and while he aimed to touch the skies, his other love was dogs. Doors of even the Bombay House were open to strays all day long.
Wow, 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 wow. What a great inspirational story. What a leader he was. What an inspirational leader he was. A great applause to him. Let's take a moment to show our gratitude and have a 2-minute silence observed for the beloved Manmohan Singh and Ratan Tata. Thank you, everyone. I remember saying of Ratan Tata, which relates to all of us. He said at a time, if you want to walk fast, walk alone. And if you want to walk far, walk together. So let's walk together and we'll go for a distance and hope to see you all soon. Let's have a photo session after the tea break, and also we request you to have some testimonials given to us and how did you feel about this event. And also I request everyone to follow us on the Instagram page, which will be displayed on the screen later. So I want everyone to follow us and tag this event. And if you have any questions in future or you need any legal assistance, you can always reach out to us. I hope we have given you all the contact information of us, and I especially thank Mr. Santosh Reddy for taking his time and making this even more memorable to us. Thank you, sir. Thank you so much. See you all in next 10 minutes. Let's have a chit chat together with Santosh. So he'll be here meeting you all. So he is available. Thank you all. Let's have some tea. And also, I think Padmaja was thinking that no girl has received a prize, right? Right? Absolutely. So no, we'll not miss that. Okay, once we are back, we'll do a raffle again. Okay? All right. Thank you all.